Hello, everyone. Yes, I want to talk about, start off with talking about the Waterloo Creek massacre, which occurred on the 26th of January in the same year. Oh, okay. Yep. Is that better? Yeah, it is. Occurred in the same year as the Myall Creek massacre on the 26th of January. A group of about 50 mounted police and stockmen came upon a large group of Gamilaroi people camped by a river near a wood. The police immediately rode down on them and charged, and the Gamilaroi men moved forward to meet them, and the women and children attempted to escape downriver. A policeman was speared in the calf and shots were fired, but accounts of what happened next vary very widely. They all agree that a number of Gamilaroi were wounded or killed. The official report says that there was about 4 people, as does that of another officer. But a third officer says it was maybe 40 to 80 people. People who visited the site days later reported dozens of corpses in the river and in the trees. Clearly people trying to escape and being shot. A journalist interviewed a Gamilaroi man in 1873, known as Terry Hi, who said that he was the last living survivor of the massacre and that most of his clan were slaughtered in it. And the humanitarian cleric Lancelot Threkold, going apparently on boasts by Nunn and his officers in the Sydney pubs, gave an estimate of 200 to 300 people killed. The police were investigating the alleged murders of 2 stockmen about 4 days' ride away, but there wasn't much indication that this group or anyone in it had anything in particular to do with those killings. And so really, I mean, prima facie, these are extrajudicial killings. Pretty straightforward. It looks more like a military engagement than a routine police investigation. There was nothing unusual about this, about extrajudicial killings by mounted police. In 1836, 2 similar sized massacres had occurred. Major Mitchell and his troops had shot and killed as many as they could on the Major's own account as they tried to swim away across the Murray River by a hill he then chillingly called Mount Dispersion. And Lancelot Threkold has other stories of a couple of other similar massacres. And of course, the work of Professor Ryan has shown various massacres in that area around that time, sometimes by mounted police, sometimes by stockmen. So these were all part of what we now acknowledge to be, or many of us acknowledge to be, a frontier war that took place between the years of 1836 and 1838. One question I want to ask, and that has been asked, that I want to ask in this paper is, why didn't they declare martial law during this frontier war? In Bathurst in 1824 and in Van Diemen's Land in 1828, the infamous Black Line and the frontier war with the Wiradjuri and the Bathurst, they did declare martial law, and a lot of the same conditions applied. So in all 3 places, there was a rapid expansion of pastoral activity onto Indigenous land, then escalating conflicts, starting with spearing of livestock, kidnapping and maltreatment of Indigenous women, which created a lot of resentment, isolated killings on both sides that then prompted larger retributory raids, and an understanding of the insufficiency of civil justice to deal with these conflicts. They were occurring, outside the boundaries that they could reliably police. And often it was difficult to identify who was involved. People didn't keep records. Settlers were very quiet about what might have happened. And so it was very difficult to hold anyone to account. And so martial law was declared in both cases in an attempt to bring a kind of a superior military force to bear and to try and restore law and order. So why wasn't it declared in this particular war? I think to answer this, of course, I need to talk about what martial law actually was and what it was at the time. And I do want to do that, but I think there were three main reasons it wasn't declared in this case. Firstly, there were changes in judicial and administrative attitudes. And Sam, in his incredibly intimidatingly impressive talk, it did talk a bit about that judicial shift. Also, there was quite a strong push at the same time as this increased colonisation, waves of increased colonisation. There was also a push in Britain on humanitarian grounds, evangelical movements that had, in 1834, they'd abolished slavery and they turned their attention to the treatment of Indigenous peoples around the British Empire. And in 1837, there was a select report of a select committee to the British Parliament, which contained a lot of very moving testimony from Indigenous peoples around the empire, as well as colonial officers, judicial officers. And they were incredibly critical. I mean, it was a searing indictment and public indictment of the effects of British colonisation on Indigenous peoples. And that caused a change in the colonial administration and a change in the tone of their instructions to various governors. So Lord Glenelg, who was the Secretary for War and the Colonies, wrote in 1837 to Governor Burke. The message was received by later Governor Governor Gibbs, but he wrote saying that sorry, I've skipped forward a little bit. He wrote saying that yes, that there was a duty to protect Indigenous people in Australia. He wrote that Her Majesty's sovereignty applied over every part of New Holland, that all natives were subjects of the Queen and within Her Majesty's allegiance, to regard them as aliens with whom a war can exist and against whom Her Majesty's troops may exercise belligerent right is to deny that protection to which they derive the highest possible claim from the sovereignty which has been assumed over the whole of their ancient possessions. So this is quite a clear step forward from saying, as people had in the past, that Aboriginal people were to be treated as if they were British subjects, or that they had the same rights and protections as British subjects. Glenelg was saying unequivocally that they were British subjects. 3 years earlier too, John Batman had tried to make a treaty with Wurundjeri elders, and Governor Burke at that stage had said that this treaty was void because it was covered vacant Crown land, a jarringly unreal phrase to us today, but that referred to what we were talking about with terra nullius and settlement, the doctrine that Australia was settled rather than conquered. And what that meant in terms of Blackstone's international law was that Indigenous inhabitants of Australia immediately received all the common law rights and protections of British subjects. Of course, this was, something that Glenelg impressed upon Governor, the governor. So along with the administrative attitudes, there were these changes in judicial attitudes. So very few cases of violence against Aboriginal people actually made it to the court in the first place, a vanishingly small amount. Of the 20 that did come to the court, all of the defendants raised self-defence and provocation as defences. And prior to the 1820s, these defences were uniformly successful. So people would say there have been lots of depredations of Aboriginal people in the area. I saw someone in my backyard. I was afraid that terrible things were going to happen and I shot them. It may have been an overreaction, but it was in self-defence. And this was successful up until the 20s. But when Francis Forbes arrived in 1824, along with the Attorney General, Sax Bannister, who was an early and articulate campaigner for Aboriginal rights, and of course, later Justice Burton, who was the presiding judge at the Myall Creek trials, this narrative started to be challenged. R.V. Johnston, R.V. Ridgway, in which a white man was executed for killing an Aboriginal man, and R.V. Lowe, in which there wasn't enough evidence to prosecute, but they did underline that the court did have jurisdiction to hang white men for killing Aboriginal people, just on purely legal formalist principles. This had started to change that idea of self-defence as being an automatic get-out-of-jail-free card. And of course, Myall Creek was a pretty clear example of the fact that juries were prepared to go along with this as well. So I've got a long way through the talk, partly because I mixed up my pages, without sort of telling you what I think martial law is. It's very much what we would think of it as today, the increased powers for the military as against common law rights of civilians, mobilisation of civilians and direction of civilians, things like curfews and so on. And also summary justice, either in courts martial or just going ahead and killing people on the field or immediately afterwards. And it's in the area of summary justice that I think one can see how, contrary to the rule of law principles, substantive and procedural rule of law principles, martial law is. Why wasn't it declared, given these changes in the administrative situation and the judicial situation? The Glenelg's instructions arrived on the desk of Governor Gibbs, who was placed in a very difficult position. Gibbs himself was concerned about the loss of innocent Indigenous lives, and he publicly reminded colonists of the duty to protect them. In his letters back to Glenelg, he says that the conflicts are often caused by white men interfering with black women and the rapid advance, up to 50 miles a season, he says, of the shepherds, saying it's no wonder a few of the hundreds of cattle and sheep get speared. But he delays putting Glenelg's instructions into practice, and because of what he says is public sentiment about the killings of white stockmen and the spearings of cattle, inflamed by articles in the Herald that frankly call, I mean, I don't use the word genocidal at all lightly, but the sentiment is frankly more or less openly genocidal. And so Gibbs was dealing with this. They didn't have the sort of administrative and military architecture to simply enforce administrative will on the population. They had to deal with articles in the Herald that said that it was the cupidity and ferocity of the Indigenous people that drove them to kill cattle and men. Gibbs was not of this opinion, but pastoralists sent him a memorial in 1838 saying, we need protection, we need the army to come in or a militia to be created so that we don't have to do it ourselves. We don't want to do it ourselves, but we will. And it's an argument that's really quite staggering. It's hypocrisy, that we need law and order, otherwise we'll go ahead and murder a whole lot of people. Having had martial law called for, why didn't it? Why wasn't it employed? I think part of this was changes in the application of the doctrine in the British Empire. The threshold for the doctrine of necessity had gotten higher. So martial law was originally about the executive prerogative. It was just the king or his representatives saying, we have the right to defend the country by any means, and we're going to do it. And so it was really only reliant on the king's feeling that it was necessary. But along with the development of rule of law principles, and especially after the Petition of Right, which limited the powers of the king to do anything that he wanted to do, and the development of this idea of the country being ruled by laws and not by men. This changed to the doctrine of necessity. It was still okay to declare martial law, not in England anymore, but in the colonies, if it was absolutely necessary to do so to preserve the state, to preserve the health of if there were, where there was an existential threat or something that looked very much like an existential threat. And so this happened in a bunch of colonies, and each time there was a debate in the House of Commons, and each time British parliamentarians expressed more and more concern about the breaking of the rule of law in the colonies. You know, Britain wanted to believe that it was bringing the rule of law to the colonies, that it was bringing the advantages of civilization to barbarous lands. It could hardly do that where it was pretty obvious that the rule of law was being flouted all the time. And so martial law, which was pretty much an explicit declaration that rule of law principles were going to be suspended, became less and less used, and the threshold for its use got higher and higher. So Saxe Bannister did believe in declaring martial law as a way to prevent bloodsheds on both sides, and he advised Governor Darling in 1826 to do so. But Darling refused to do it, saying that there wasn't enough of a threat. And I think this is another factor, is that by 1838, unlike in Bathurst, where the entire Wiradjuri nation was mobilised to, it was some of the fiercest conflict that Australia has ever seen, in order to attack the settlements, and they really did face a credible military threat. By 1838, this wasn't really the case. And so it didn't really meet that standard of necessity. The evolution of the doctrine also, there was a case in 1838 in Canada where a joint legal opinion said that martial law didn't in fact confer extra powers on the governor or on the military. It was more just a signal that suppression was going to occur. So there was starting to be this sort of vitiation of the doctrine. Another issue was that summary justice couldn't be applied where there were civil courts. Where you could bring someone to a civil court, from the early days of martial law, it was considered not to be okay to have courts martial or summary justice. And in this case, although they could have mounted an argument that they couldn't have brought people to court, this would be quite difficult to convince anyone of. As far as receiving indemnity for any actions that might otherwise be looked at as murder or assault, that would be something that would have to be done by a British Parliament. And as we saw, British Parliament was not in a mood to be particularly sympathetic towards that kind of claim. So just to conclude, in the end, there was a perfunctory inquiry by the Executive Council into the massacre at Waterloo Creek, which somehow found that it was all done in self-defence. Really, having read some pretty extensive accounts by Roger Noyes, it's really hard to see how that would possibly apply. The accounts of massacres by mounted police didn't result in any curbing of their activities. In fact, the concept was expanded in the later use of the even more feared and even less accountable mounted native police in Queensland. Myall Creek, too, was not the beginning of a new era of judicial enforcement of rule of law protections for Indigenous people, but it was a rare exception. Likewise, the report of the Select Committee didn't result in any halting or slowing down of colonisation, which instead increased exponentially in the 1840s, or in compensation for dispossession, or in agreements with Indigenous Australians, unlike, say, New Zealand. Instead, it ushered in a new era of protectorships, which through paternalism and absence of understanding, not to mention bad faith in some cases, caused a lot of further suffering. I take heart from the fact that in acknowledging the frontier wars, we're calling attention to the inconsistencies and gaps in the legal narrative of colonisation. The country was not settled. It was taken through a combination of piecemeal, if bitter, conflicts and adverse possession, essentially a kind of armed robbery. This means that the legal basis for the arrival of the common law is flawed. Mutual cession of sovereignty would not change this, but it would mean that Australia was presently shared by agreement. This is why everyone in legal academia, in my opinion, should be a supporting treaty, not because it is just and fair and right, but because it might finally begin to reconcile Australia's legal history with itself. Thanks very much.
Okay, we've got time for probably 2 questions. Has anybody got any questions? Yeah.
Thanks very much, Ben, for a really interesting talk. I just wondered, was there ever any contemplation that martial law might be useful in the protection of Aboriginal people, that it could work the other way as well? Or was that just too far beyond contemplation in the context of the times?
No, not at all. In fact, it was the reason given, one of the reasons given. It's a really good point, and one that I did actually have in my notes, but I didn't address. So yes, absolutely. Whether particularly sincerely or not, I think in Sax Bannister's case, when he recommended martial law in Bathurst, he sincerely believed that it would help, would protect our Indigenous people from colonists who were taking, pastoralists taking the law into their own hands. And it would mean that there was a presence on the ground that would make them more accountable. That was the idea. In Tasmania, the same justification was given, that it would actually protect the Indigenous people. I think not so much in good faith in that case, given that they actually wanted to completely expel Indigenous Tasmanians from the mainland, or at least at the beginning, it's just from certain sections of the mainland. But that was a big thing. They were saying, look, you know, in the context of a sort of really quite a strong humanitarian push right from the beginning of colonisation. Henry Reynolds talks about this in This Whispering in Our Hearts. You know, there were people saying in the newspapers saying, look, as Christians, what are we doing here? And so that was a way of addressing those concerns as well.
Last question.
Yeah. Can I ask the flip side of that? Do you think there's an argument to be made that martial law was declared because it made things bureaucratically easier for the governors?
Yes, that too. In a number of interesting ways. So after 1824, you needed the approval of Legislative Council, or later the Executive Council, for a lot of stuff, but not in cases of riot or insurrection. So declaring martial law was a very visible and recorded way of saying, I'm going to do what I want to do as the governor. It also meant that there were a lot less record keeping. Martial law is a lex ex scripta. There's no rules for how it's meant to be applied. And so it stops discussion, and therefore it stops meetings taking place. It stops minutes for those meetings, and you can have this complete absence of reports. Yeah.